Hello, this is Henry Quillian. We're here at Taylor English Duma in Atlanta, Georgia, at Quillian's Kernels, also known as Litigation Fundamentals with Henry Quillian. We have a very interesting topic today, which is recovery of attorney's fees in federal court actions. And we have two very experienced speakers in this regard who have been successful in recovering attorney's fees in federal court. As you know, out there in the world, we are not providing direct legal advice to you as attorneys. We are providing sort of educational material by which your attorneys could use information to assist you or to consider your case. And also, if you're acting pro bono, we highly recommend that you get an attorney, but we are not providing you legal advice. We are just providing you information that we think might be helpful. My name is Henry Quillian, but our speakers today are two of our other excellent litigators. We have a large group of litigators here at Taylor English Duma. And the first is Don Anderson, who is a long-term friend of mine, but he has been litigating intellectual property cases in federal court, obviously, as well as aviation cases and quite a number of general commercial cases for quite a number of years. And he is one of our lead lawyers here at Taylor English. So if we could invite Don up, he will also introduce Catherine Bannock after he gets done with his presentation. Thank you, Don.
Thank you very much, Henry. The topic today is attorney's fees recovery in federal court. And perhaps a short disclaimer is that the procedures in state court are in many respects similar, but there are also some very significant differences in the applicable rules and statutes. So what I'm about to say about federal court is tailored just to federal court. Some of it might be helpful in state court, but it's not. But that's a separate topic. The starting point in talking about recovery of attorney's fees in federal court always needs to start with the idea that the federal system recognizes and follows what's called the American rule, which means that each party bears their own attorney's fees. That's the general rule, and probably, even though we'll talk about some fairly significant exceptions today, that general rule is probably applicable in certainly the majority of cases. And so the expectation, I think, of the parties in federal court, unless, as we talk about in a moment, there's a contract or a statute, should be that they'll probably be required to bear their own attorney's fees in federal court litigation. But the starting point always is the American rule, and that's the general rule. Now, the exceptions to the American rule in federal court are, of course, if there's a contract that involves fee shifting, that contract can be the basis for an award of attorney's fees. And to some degree, the contract can also dovetail to some degree with some state law rules. For example, in cases that are governed by the Uniform Commercial Code, you might be able to make a claim for damages for breach of a contract that might also include one's attorney's fees, not necessarily in the case you're litigating, but perhaps the case that's the subject of the overall litigation. So it's either the contract that the parties are litigating directly in the case, or it might even be an underlying contract that provides for indemnity and possibly a recovery of attorney's fees. So the first exception to the American rule is the contract. The second exception to the American rule is whether there is a common law rule. And frankly, I've never recovered attorney's fees under these common law exceptions, but it's important to recognize them. One is called the common fund exception. And if a party recovers a party through its efforts recovers a fund that is available for other parties then it might be possible for the court to award attorney's fees for the recovery of the common fund before it's ultimately distributed to each of the beneficiaries. There also is another more or less common law exception, which is if a party has disobeyed a court order, and that's part of the court's contempt powers. And so that's another exception to the American rule. If in fact what one is doing is enforcing a court order that's been disobeyed, then it might be possible to recover attorney's fees simply because the basis for the claim was that a court order has been disobeyed and there's been contempt, and the court is in a position to award attorney's fees because of the failure to obey that court order. A third common law exception involves bad faith, but as Catherine Bannock will tell you in a moment, that pretty much is subsumed within what we call the court's inherent powers. So I'm going to let Catherine talk about that. But it's also referred to occasionally as a common law exception to the American rule, is that a party's bad faith in the underlying transaction or in the conduct before the court could conceivably give rise to attorney's fees. And I'll digress just a moment. When you get into the court's inherent powers, there is a question about whether a court can use its inherent powers to, in essence, punish a party who's been guilty of bad faith in the underlying transaction, as opposed to bad faith in the conduct of the litigation. And there is, I think the majority rule is that the court's inherent power in federal court is limited to penalizing the parties for their bad faith in the litigation, and not really going back into whether they were in bad faith in some way in the underlying transaction. Although that gets to be a fairly difficult question, and we've had it come up in some cases. So we've talked about the two exceptions to the American rule: the contract, and common law. The third exception that I'm going to talk about is statutory exceptions. And this is really important to think about right from the very beginning of the case, because the statutory exceptions may be substantive statutory exceptions, or they may be procedural statutory exceptions. The substantive statutory exceptions could either be federal law statutes, or they could be state law statutes. And I'll give you an example of that, or several examples of that. Of course, in federal court, I think we all recognize that there's a number of federal statutes that basically provide for fee shifting. Typically in the civil rights area and in the employment context, there are substantive statutes which will provide for awards of attorney's fees. Similarly, in the area of intellectual property, there are provisions for fee shifting in patent cases and for trademark cases under certain circumstances. And so those are some other examples. In one case recently, I asserted basically a product liability claim, but I brought it under the Magnuson-Moss Warranty Act. And the Magnuson-Moss Warranty Act conveniently provided a basis for recovery of our full attorney's fees in what was basically a consumer product liability case. So it's important to really look carefully at the substantive bases that are available in your case, in litigation, to see whether there is a remedy or a right or remedy available under federal law that provides for attorney's fees. It's important to remember that state law also can provide a basis for attorney's fees under various substantive state statutes if those claims are pending in federal court, either based on diversity or pendent jurisdiction. In the IP area, there are a number of state statutes involving unfair competition and state law trademark violations and counterfeiting and seizures and that type of thing. And in one of the cases we'll talk about, we actually used asserted a counterclaim on behalf of a defendant whose property was seized under color of a state counterfeiting statute. And the state counterfeiting statute says if the property is improperly seized under that statute, the owner of the property is entitled to their attorney's fees in recovering their property. So that's an example of a state substantive rule that may be applicable in litigation in federal court. There also are procedural statutes, and Catherine is going to talk about procedural statutes and rules, and Catherine's going to talk about one of them in a moment, which is 28 U.S.C. Section 1927. So that's an example of a federal procedural statute that provides for the recovery of attorney's fees. Of course, I'll talk in a moment about Rule 11, and of course that's a basis for the procedural basis for recovering attorney's fees. The question of whether state law procedures are available in federal court is, I think, fairly well decided at this point, but it's something to at least consider. I think the rule here in Georgia is that OCGA Section 915.14 does not provide a basis for recovery of attorney's fees in federal court. Interestingly, in Florida has an attorney's fees provision that involves offers of settlement and fee shifting, and also has a provision for frivolous litigation. And I have in the past had attorney's fees awarded by a federal court in Florida on the basis of the Florida state law frivolous litigation statute, and that was in the Middle District of Florida, and the judge held that was the provision, and that was consistent with the majority of the rules or rulings in the federal courts in Florida at the time. But in Georgia, we have a different situation, and the federal courts here, for the most part, have not applied 915.14 in federal court. And I don't think they apply OCGA Section 13611 either. But I would double check that to make sure there hasn't been that that's correct. And there, of course, there's another substantive or procedural rule, I guess, in Georgia, OCGA Section 13111, which is recovery of attorney's fees on notes. And that may very well be applicable in federal court. I'm not sure. But again, these are examples of looking to federal substantive law, state substantive law, federal procedural law, state procedural law, to try to determine whether there's an acceptance of this American rule that each party's got to bear their own attorney's fees. And so it's very important to look at all of those. There's one other example I guess I should mention, and this is I mentioned it briefly before, but it does involve the Uniform Commercial Code, and it comes up occasionally in the context of patent cases where one party makes a claim for indemnity against another party claiming that there was a breach of the warranty of non-infringement under the Uniform Commercial Code. And so if one party has been obligated to defend the patent infringement case and incur attorney's fees because they're of a claim of infringement, then that party who's defending that claim may be able to go back to the manufacturer or the seller of that, specifically the seller of that product, and say, under the Uniform Commercial Code, you've warranted that this was a non-infringing product. I've had to defend against this claim now that the product you sold me was non-infringing, and I've had to incur hundreds of thousands of dollars, and you didn't come in and defend me. So now you're obligated to pay me for the cost of defense of defending this claim of infringement. And what really gets interesting is whether you win or lose the case, because occasionally someone will say, well, it wasn't infringing because you won the case, and the rules tends to be, although you get into some controversy, but the rule tends to be, no, even though I successfully defended your product against these infringement claims, I had to do it, and really this is your burden, and it's a breach of your warranty of non-infringement. You should have come in and defended these cases. So again, that's an example of a state law substantive rule under the Uniform Commercial Code, the warranty of non-infringement, that then provides a way for a party in federal court to recover their attorney's fees. So having talked about these various substantive rules, now the main procedural rule in federal court, as we all know, is Rule 11. And Rule 11, from my experience, is probably the rule that is most likely to result in a recovery of attorney's fees. Catherine's going to talk about some cases we've had which have involved recovery of attorney's fees under 28 U.S.C. Section 1927 and the court's inherent powers. And the interplay between those cases, those statutes, and the court's inherent powers that Catherine will describe, and Rule 11 is such that they're not mutually exclusive. In other words, it's possible that conduct could be sanctionable under Rule 11 and also under 1927 and the court's inherent powers. But there is somewhat of a bias, if you will, that within the court that the court would prefer to award attorney's fees under Rule 11 rather than having to more or less go out on a limb and try to find a basis for attorney's fees under the higher standards of 28 U.S.C. 1927 and the court's inherent powers. So the reason I'm saying that is Rule 11 really places a burden on the party who's going to seek those attorney's fees to act proactively or to act promptly. As we all probably know, there's a 21-day safe harbor provision in Rule 11. And when you're in the midst of litigation, that can become somewhat problematic. If something happens quickly in litigation and all of a sudden you've got to file briefs and incur a lot of expense, you may say, well, why do I want to send somebody a proposed Rule 11 motion? Because I'm going to have to write this brief tomorrow, and the 21 days is not going to run until I've already incurred all of these expenses. And so oftentimes it's easier to say, let me just go ahead and write the briefs and I'm not going to deal with the Rule 11. But probably the better practice is to go ahead and at least serve that Rule 11 motion promptly as soon as you have a reason to do it. And of course I guess the change for many of us older litigators is that in the old practice you used to say what we just call it a Rule 11 letter, and the clients sometimes say send a Rule 11 letter. Well, it would be nice if it were that easy, but you really have to prepare a Rule 11 motion, and the Rule 11 motion that you prepare is the Rule 11 motion you're going to file. So you can't just do some form motion and hope that a federal judge is going to look kindly on it if you file it later on. It really does need to be tailored to the circumstances. But having said that, the law is not that difficult, and frankly, if you've done some of these Rule 11 motions, you can pretty much adapt them to the facts of your case and without having to research and rewrite all the applicable law. So that's an argument. If one approaches the service of a Rule 11 motion that way, it might make it easier for you to say, okay, I really do have time to get this Rule 11 motion. I just need to really take a little bit of time and articulate the bases for inserting Rule 11 in this case. The standards under Rule 11 are essentially objective standards, which is also very important because you don't have to really deal with whether the opposing party or the opposing attorney is acting subjectively in bad faith. And they're stated, and we're all very familiar with them, and they're very similar to the state law provisions too. But they involve representation to the court, and for the most important one is that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law, and that the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And then finally, I guess for defendants, the denials of factual contentions are warranted on the evidence, or specifically so identified or reasonably based on belief or a lack of information. So these are fairly objective standards by which one can evaluate the merits of the legal arguments and the sufficiency of the evidence. And so pretty much right from the beginning of the case, you might take a look at the case and try to decide whether there really is going to be evidence to support it, or whether it supports a legal theory. And when you do that, then it's time to serve that Rule 11 motion. The opposing party has 21 days within which to withdraw the offending pleading. I don't know exactly how it comes up in the Rule 11 context. Occasionally, people will try to dismiss the case if they're able to do it. If an answer or counterclaim hasn't been filed, they may be in a position to voluntarily dismiss their case in federal court without the other party's consent or without a court order. But that doesn't avoid sanctions entirely. So someone may attempt to do that, but still, depending on the 21 days, they may still be subject to sanctions.
Don, when do the sanctions start to run if you serve the motion? The other side.
I thought someone was going to ask that question, Henry, and I don't know the answer to that. I should. I guess, in my experience, we've always treated the sanction, the attorney's fees, as starting to run after the 21 days. Now, I may be wrong about that, and I know we've gotten into some arguments about that, and it would seem logically that if you served it in a timely fashion and it was ignored and the 21 days passed, then one could go back and recapture the attorney's fees incurred in the interim. So I would think that's logical, but I also know that to some degree in experience, we've kind of got into these discussions about, well, we had to do this before the 21 days ran, and so that bottom line is I don't know the answer to that.
The classic circumstance would be you get a totally frivolous complaint, so you send a motion right away before you file an answer.
And you've got to file your answer within 20 days.
Right, and your answer might take a lot of work.
Yeah.
And so you would hope that you could recover the cost of filing an answer if the other side just ignores your motion.
Yeah.
And then you win a motion to dismiss, let's say.
I would certainly make that argument. As I say, I don't know the answer. I can't just tell you cold that that's the way it is. I'd certainly make that argument. The other thing about Rule 11 sanctions is that except for misrepresentations of the law under 11b2, the client also can be subject to the Rule 11 sanctions. It's not just the attorney. And Rule 11 also says it's the attorney and the law firm. But the attorney, the client, and the law firm are all subject to Rule 11 sanctions for misrepresentations of fact and for insufficient evidence. So it is a very broad application. And frankly, it creates some very difficult situations for an opposing counsel. And we've been involved in some cases where when a sanctions motion has been filed, some attorneys will say, we have to withdraw from the case. We've now got a conflict of interest. We've also seen some cases where the lawyers and the clients kind of tap dance around it, and it makes for some really interesting hearings when the lawyers saying, well, the client told me this, and trying to throw the client under the bus, and so it's the conflict issues are not insignificant. Rule 11 also does not apply to discovery disputes, and so that's something we'll talk about in a moment under Rule 37. But Rule 11 doesn't apply. To give you an example of a case that we were successful in recovering attorney's fees on, we were involved, Catherine and I both were involved in a case that was brought under the Georgia Anti-Counterfeiting Statute and involved a seizure of an offending product that was claimed to be a counterfeit. One probably would need to go back and read the Georgia statute but what it says is that any person who holds a registered trademark in Georgia may bring an action under this statute, and then the statute provides for, among other things, seizure of the infringing property. And in this particular case, the plaintiff's attorney filed a lawsuit and actually filed a motion, ex parte motion for seizure of the property, and he quoted the statute. The only thing that he didn't do, the only thing he didn't do is he didn't put in the language about the holder of a state registered trademark. So the statute, according to his paper, said any party may bring an action under this statute and any party may seize infringing property. And the lawyer went into the state court of Fulton County and the state court judge said, that looks pretty good to me. Here's your order of allowing you to seize the property. And they went to the trade show, which was being held in Atlanta. And a big truck, this is a huge piece of woodworking equipment. And they went to the trade show and much to the chagrin of the party that thought they owned it, loaded it in the back of a truck and took it off to North Carolina. And then the lawsuit proceeded from there, and we were brought into the lawsuit after that had happened, and of course immediately recognized that that had been an improper seizure. We immediately sought our attorney's fees for the wrongful seizure under the state substantive statute, the Anti-Counterfeiting Statute. But we also served a Rule 11 letter saying that that pleading certainly misrepresented the law. And I've got a copy of the opinion here. It's about and the case gets more interesting, and Catherine's going to talk about the rest of it. It's about a 49-page opinion, but the first thing that got the judge's attention, and really got his attention, was when he read the statute and he realized that it specifically required that the plaintiff hold a Georgia trademark registration, and there was no way that you could have accidentally misquoted the statute. Everything else on both sides of those words was quoted verbatim, and there were no ellipses, there was no nothing. It was just a blatant example of misquoting the statute, and that really was the first problem the judge had. Yeah.
Could the party get damages for whatever injury they incurred as a result of not being able, I guess, to participate in the trade show?
Yeah, that's another element of damages that what is available under the Georgia Anti-Counterfeiting Statute. If it's a wrongful seizure, then we argued they were entitled to all kinds of damages. But the statute also specifically provides for attorney's fees. So that's an example under when we sent the Rule 11 letter. And candidly, I don't remember exactly what their response was. This is maybe a good lesson for anybody who's involved in this. They didn't immediately withdraw the offending pleading. Instead, they wanted to negotiate it. And they said, well, we'll withdraw the offending pleading if you do such and such. And we said, no, your job is to withdraw the offending pleading. We don't have to do anything. And when this was decided by Judge Pinnell in the federal court, and Judge Pinnell specifically addressed that, and he said, Rule 11 is not a negotiating position. You don't get to say, well, I will withdraw it if you do something that I want you to do. And so, again, Rule 11 is a pretty serious situation, and the duty is to withdraw it without condition.
Just wanted to be clear, since we're on tape, you mentioned the Rule 11 letter. Was this in the time period when you actually had to send the motion?
No, I'm just dating myself. It was a Rule 11 motion, and which was served, and then this was their response. Instead of withdrawing a plea within 21 days, they negotiated, and then when they failed to withdraw it, then we filed the Rule 11 motion. And Catherine will tell you more about that case, because it gets worse from there, and it's a very interesting example of how serious these sanctions can be in federal court.
So Don, for our friends out there in the world watching this videotape, you prepare a motion that's not yet filed and you send it to the other side in the format and the form that's going to eventually be filed.
Correct.
And then after 21 days, when they don't withdraw the offending pleading or whatever, then you file the motion you previously prepared and served.
Correct. Exactly.
Do you have to reserve the motion when you file it? I guess you do, or I guess with ECF it'll automatically serve.
That's a good question. I think it probably is reserved automatically with ECF. That's an excellent question. The other area of attorney's fees under the rules, of course, is Rule 37 for discovery disputes, and we're all familiar with Rule 37. under the new rules that have recently been gone into effect, I think we've got a meet and confer obligation, and we've got a whole series of obligations under Rule 37 to meet and confer and to involve the court and a number of things. So I would say, without going into detail, that's a subject of another presentation, but without going into detail, I think it would be very important to be sure you're following each of those requirements. But once those requirements have been followed and you're in a position to file a motion to compel or a motion for protective order, then Rule 37 actually does provide that the court shall award attorney's fees. And some lawyers may be surprised by that. They may think, no, I've got to really pretty bad. But there are federal judges out there who will look at a discovery motion and say, you know, I've had to enter this order and the other side's going to have to pay the attorney's fees. So that's an example of fee shifting as well. So those are the statutory exceptions and the rule. I'm sorry, those are the statutory exceptions and the rules, with the exception of 28 U.S.C. Section 1927, and then also the inherent powers of the court. Catherine Bannock is going to talk about those, and Catherine is extremely experienced in litigating in both federal and state court, and she's been very heavily involved in all of these cases. And so she's going to talk about 28 U.S.C. Section 1927. And
Don, one quick follow-up point. You had posed the question, can you assert a 13611 claim in federal court?
Yes.
Years ago, I successfully did at a trial. We won attorney's fees under that section. I think there's case law to the effect that says you can bring
you can do that.
an OCGA 13611 claim in federal court.
Well, that's good, and that would distinguish it from 91514, which I think has been precluded because the federal court rules provide the procedural rules, but 13611 is substantive.
I'll also point out that just yesterday I looked at a case, the Wheatley case. It was decided by Judge Batten at 9/11/68, even though it falls under the procedural rules in the Georgia Official Code of Georgia, is a usable statute in federal court.
Well, that's very important. That's a very important decision. Yeah.
Both 9/11/68 and 13611 can be asserted in federal court only with respect to state law claims. I assume that was implicit in what you both were saying.
Yeah.
But we're filing a brief, Kelly's filing a brief on Monday where we were awarded $307,000 on 13611 in federal court.
Excellent.
So it's very useful. The other point about when the sanctions begin to accrue, by analogy, as I recollect, under Rule 68, the sanctions begin to accrue after the 10-day period expired. And so it seemed to me that if you're looking for guidance somewhere on how you would apply Rule 11, you would look to Rule 68, and your entitlement to attorney's fees would begin on the 22nd day, not on day one.
Yeah, I think that that's really a very, I think there are really two sides to that argument, because the other side of it would be that the 21 days is a safe harbor, which simply means that you can avoid what's already accruing by taking some action within the 21 days, but after you're out of the safe harbor, you know, then you're subject to the entire claim. So, I don't know, I haven't researched that issue, but I can see the argument. You know, I can see both of those arguments being very analogous and good arguments.
And to respond to Henry's concern, it seems to me that what you would do is once you serve the Rule 11 motion, you ask for an extension of time to answer. And if they refuse to give you an extension of time, that would enhance your argument that I ought to be entitled to recover my attorney's fees for having to prepare an answer that was otherwise unnecessary. But if you don't take any initiative to even ask for extension of time, I wouldn't think that argument would be very persuasive.
That's a good
Good procedural one.
I mean, I think that's really excellent, because I think a lot of, in seeking these recovery attorney's fees in federal court, a lot of it really will depend upon whether the court thinks that one party or the other has been reasonable and has attempted to avoid the harm. So, Catherine?
Thank you, Don.
Thank you, Don.
Okay, so I'm going to talk about sort of a tandem, the court's inherent authority to manage the litigation in front of it, and call it the inherent authority to punish both attorneys and litigants, as well as 28 USC section 1927, because they're fairly analogous. Here are the main differences. When you're seeking to use the court's inherent authority to punish acts of bad faith, this can be used to capture the bad faith and punish the bad faith of both the party and the attorney. 28 USC section 1927 is directed to attorneys only. And the standard under 28 USC section 1927 is whether the attorney has multiplied the proceedings in a way that's unreasonable or vexatious. Inherent authority, the key is, and one of the most cited cases is probably Chambers versus NASCO, Inc. The key in all of the cases that talk about inherent authority talk about the key to it being bad faith. And some of the courts say that this just is an offshoot of the common law authority of the court to punish acts of bad faith in front of it. Section 1927, by contrast, there's a bit of split among the circuits as to whether it requires bad faith and is premised on subjective bad faith, or taking a cue from the actual language of the statute, you can have an objective standard of unreasonable conduct. For the 11th Circuit, where we practice, the 11th Circuit has gone with the objective standard of unreasonableness in vexatiously pursuing a frivolous claim. In that case, it's Amlong versus Denny's, Inc. But what the 11th Circuit has tacked onto that is it's got to be tantamount to bad faith. So as a practical matter, if you're looking for attorney's fees under 1927 against an attorney or its law firm, you have to show conduct that is pretty much tantamount to subjective bad faith. And what this looks like is in practice is we've gotten them successfully where you have backdated documents. In one particular case that Don and I worked on, the other side prepared these closing documents that said they were effective as of such and such a date. There's no other date on the document. They were created in the course of the litigation by the litigation attorney pursuing the claim and presented in discovery with no comment, as if they had been prepared several years ago in connection with the transaction. Allowing your client to perjure himself in a deposition and standing by silently and not attempting to cure it, and if that's unsuccessful, not withdrawing, is another instance where a court will find bad faith and will sanction either the attorney under 1927 or the party himself under its own inherent authority. And then also, sometimes you don't have the opportunity, for whatever reason, to send a Rule 11 letter. In one case, it's Peer or Peek versus Lewis. There was a situation very much like this case that Don has described, where an attorney was foreclosed from pursuing a claim under certain language in a statute and very neatly omitted that language and pursued the claim anyway. Even though there wasn't a Rule 11 letter out there, the court, under its inherent authority, entered sanctions against that attorney. But again, the key is bad faith. You've got to have some showing of bad faith type conduct. And since this is a punitive type of measure, it's somewhat analogous to criminal contempt proceedings, even though 1927 doesn't on its face require notice and a hearing. I think it's always good practice to allow, if you're seeking the sanctions, to request oral argument, give the other side notice and an opportunity to be heard. I think it would be error and not consistent with due process to at least give the other side, if you're seeking them, an opportunity to be heard. If you're on the other side of it, ask for oral argument and raise that issue as error if you're not given an opportunity for notice and a hearing. And so just to give you sort of a real life example of how these kinds of sanctions play out, continuing Don's case, so the first problem that the plaintiff had in that case is that they directly misstated the statute under which they seized our client's woodworking machine. One of the requirements in that case was that they had to produce, the state court judge ordered them to produce a report since they were holding our client's machine, and the question was whether this was our client's machine manufactured by our client or a machine that was manufactured by the Italian company with our client's trademarks on it. Whose machine exactly was this? So they hold the machine for a number of probably 30 to 60 days or more, and then they produce this inconclusive report. And of course they would have known looking at the machine whether it was theirs or not. So we sent discovery to try to elicit whether or not this was in fact our machine or their machine, and they evaded responding to the discovery requests. And so then we noticed a 30B6 deposition and got a lot of, I don't know, I don't remember, I can't recall, I never read the report, I don't know. So we filed a motion to compel under Rule 37 and said, look, because Rule 30B6 requires you to produce a prepared witness, you cannot put up an unprepared witness who says, I don't know, and this is the tantamount to a failure to appear. So in response to that motion, the attorney says, well, I did prepare this client. I had him read all of these materials the night before the deposition, and I spent 4.5 or however many hours going over these materials with this client. But the problem, in the attorney presented this in the way of a certification. And of course, as an attorney, you don't have to certify what you say to the court, right? Because everything that, you're an officer of the court. So everything that you say to a court is presumed to be said under oath. So this attorney took this extra step of presenting the certification saying, I in fact reviewed these materials with this client the night before the deposition. The problem was, though, during the deposition, this same attorney kept jumping up and telling his client to be quiet and answering for him in the deposition saying, he already said he didn't review this the night before. So the attorney has allowed his client in the deposition to testify that he didn't prepare and he hadn't read a particular report, and is interjecting himself, confirming that the client hadn't prepared. And then when he's faced with a Rule 37 motion, he's certifying to the court that he did in fact prepare this client. And so what the judge said in his order was, either the client has perjured himself or the attorney is lying in his certification. And neither one of these things are good things. And if the client was lying, he had an obligation to cure the perjury or withdraw. So we ended up with sanctions under, I believe, both the court's inherent authority against the party and against the attorney under 1927. So that's a sort of a real-world example of how these two provisions. One is a common law concept. It's just the court's inherent power to manage its affairs. And again, it requires a showing of subjective bad faith, an intention to do something bad, make up documents, misrepresent the law, allow your client to lie under oath. 1927 is multiplying the proceedings. So examples of that would be putting up the witness who is unprepared to testify, not responding in good faith to discovery requests, allowing the client to produce this inconclusive report when the client knew good and well whose machine this was. And let's see, and I guess the last bit for all of these attorneys' fees, procedurally under our local Rule 54, what you want to do is at the close of the case, when you have a final judgment entered, your timeline is 14 days after the entry of the judgment. Then you've got up to 30 days after that to file your attorney's fees. And we have always asked for attorney's fees in connection with actually preparing the attorney's fees motion. Any questions? Yes.
Is this, if you have a case where you believe that across the board, all the people who obviously should know something on the other side all claim that basically that they're idiots or dolts and don't understand, don't know something, then is there any opportunity under this scenario, for instance, when you go take all their depositions and they all say they don't know the obvious, and of course one of the elements of the claim that you're asserting is that they have to know something. So is there an opportunity to make a motion under this either during the course of the litigation or do you have to wait to the end? Or is there no opportunity in that scenario?
Okay, well,
Just for dumb witnesses on the other side, not smart people.
yeah, well, this wasn't just a dumb witness, and it's tough because a lot of people will default to, I don't know, I don't remember, I don't recall. I mean, the great thing about a 30D6 deposition is the burden is on the testifying witness, the representative, to become prepared. And if that witness is not prepared, then it's the equivalent of not appearing at all. And so this is how we got this ball rolling. This witness tried to play stupid, and there was enough playing stupid that the judge caught on to what was happening. And then the lawyer, when confronted with the reality of the fact that he had failed to prepare this witness, and this witness was going to be sanctioned, then he very foolishly threw out this certification about how he had prepared this witness after encouraging him to lie about not being prepared. In terms of the timing, we filed this motion. There's no time limit on. Certainly, you want to do it before the close of the case. But we filed our motion for attorney's fees. What's interesting is we initially filed it not to get attorney's fees. We wanted to just dismiss the case. So we filed our motion under the court's inherent authority in 1927 to simply get the case dismissed. And we tacked on to the end of our motion a 2-sentence throwaway, please give us our attorney's fees. And so this was done sort of mid-litigation, and we received our award of attorney's fees mid-litigation. The court allowed the case to continue because, in the judge's opinion, there were some potentially valid claims in it, but he felt like the sort of the past conduct that had gone on was worthy of sanctions. Other questions?
Is there an element of trying to get, as far as trying to recover money at the end of a case for things that have gone on in the case, isn't there an opportunity to recover costs associated with the case?
Yes, and that is the same procedure for filing a motion for attorney's fees under Rule 54. You submit your bill of costs, or the itemized costs that you are entitled to as a prevailing party. Those don't typically include it, just so there's no, because I've had plenty of people ask for attorney's fees with no basis for it under Rule 54. Rule 54 is not a substantive right to attorney's fees. It is a substantive right to costs for a prevailing party, and it is a procedural mechanism for moving for attorney's fees under the statutes that Don has mentioned, or the court's inherent authority, Section 1927.
Okay. Has anybody done a motion for costs that's in the room? I see Bill. Has anybody participated in preparing one of those? Maybe Emily?
I didn't participate.
Can you tell us how you went about getting that prepared along with whatever attorneys you were working with?
Okay. It's different in federal court than state court. You can apply for a lot more categories in federal court. And there's a form they provide, AO133. Is that how they number their federal forms that you can use? And it lists everything, fees to the clerk, fees for service and summons and subpoenas. And as a paralegal, this case, when I started on it, was about 5 years old. And I asked the accounting department, I gave them the client matter number, and they could send me a long, useful list of costs that had been charged to this client matter number. But for backup, they said, oh, that's gone to archives. We can't help you with backup. I'm not sure backup was absolutely necessary because the attorney signs an affidavit, and I think it looks better and it impresses the judge to have all your backup for all your different costs.
That'd be like court reporting fees and stuff.
Yes, there were a lot. In fact, that was probably the biggest cost. Fees for printed or electronically recorded transcripts necessarily obtained for use in the case. And but for some of the things it wasn't obvious down the bottom. Other costs we put in for parking and travel. Went into Lexis and did a search on successful. In fact, even naming the judge. You know, who has applied in front of this judge and gotten a bill of cost awarded, and what categories of things did they get awarded, and travel was one of them. Some people attached briefs where they would cite case law saying, you know, this person got reimbursed for their cost, you know, airfare to deposition. So that was useful, and then just using all that pulled together models of successful other examples was pulled together.
So filing fees, transcript, Lexis costs, copy costs.
Fees for service of summons and subpoena, and when we had to spend $5,000 because the guy was so hard to find, and we had to get a private investigator. Then the other side files a motion saying we object, and then you can explain why we had to spend so much, and got pretty much everything we put in for.
The cost can be pretty substantial, and the other side does have the opportunity to object. If there's no objection, then the clerk will go ahead and tax the cost presented.
There's one other thing I would note too, that Catherine's been describing the procedure here in the Northern District of Georgia. In some of the federal courts, particularly in the Northern and Southern District of Florida, there's actually, and I've seen it in other federal courts as well, there's a requirement that you submit your attorney's fees on a monthly basis. And I believe, if I'm not mistaken, that you've actually put your fee bills in under seal, but you put the total amount on the outside of the envelope, so it's public. And I think the idea there is so that at the end of the case, a party can't claim that they're surprised that there were hundreds of thousands of dollars of attorney's fees. They've seen a running total as the case has proceeded, and they can't really argue that it's unfair that they've been required to pay all of those fees at the end of the case. And we have seen some case, in the case Catherine described involving the woodworking machine, we got into quite a battle over what were the reasonable fees. And the court actually had a magistrate judge go through and each line item and decide whether it was reasonable, which was a pretty incredible process. In another case where we recovered attorney's fees, we were able to basically categorize the fees by issue, and the opposing counsel, rather than going through the difficult process of arguing them line by line, just said, well, I don't like that category, I'm okay with this category, and frankly, we were able to negotiate that out, and you know, with a little bit of give and take, we came up with a pretty substantial amount for the attorney's fees. We've got another case pending right now where we fees. And the other side, even though we filed an itemized complaint for attorney's fees, has not made any objection to the reasonableness of the fees. Instead, they re-argued the issue of whether they should be obligated to pay fees, but they didn't address the issue of reasonableness. And there's some fairly good district court and appellate law out there that says that if you don't make objections to the specific items, then you waive it. Of course, if you really get into the middle of one of these disputes about, yeah, I object to that line, and then go to the next page and so forth, there's a pretty biting decision by Judge Carnes before she went up to the 11th Circuit, which indicated her displeasure for having new litigation over the whole issue of attorney's fees. So it probably is best if you can do whatever you can to try to present them in a way that they're well categorized, well organized, and try to work through it.
Have you seen a case where you've asked for the other side's attorney's fees, the reasonableness of your attorney's fees? Because if they invested a similar amount to litigate the same case, then that would be one indication of reasonableness.
We've certainly thought about that argument before, and it's one reason, frankly, why I haven't seen anybody object to our hourly rate yet, because that's the first thing you ask is what their hourly rate is. I want to say in the case involving the woodworking machine, we thought about that, and it actually got into the 11th Circuit. They filed an appeal, and it got into the mediation process in the 11th Circuit, and I think that came up in the mediation. It certainly was one of our arguments. But we didn't have them actually, submit their fee bills and have them prepared. And in hindsight, it might have been a good idea. I don't think the magistrate was thrilled about reviewing our bills, and I think he'd been even less excited about reviewing theirs. And that would have been, so that kind of falls in the judgment category as to whether that's a good strategy. But I think he should do it if they're really out of line.
I used the opposite argument where we lost the case and the other side was asking for, I think, $4.50 an hour, and I gave them our rates to the client and argued that our rates were reasonable, which were about $200 less or $150 less than what they're charging, to say that these are the reasonable rates, but it didn't resonate much with the judge.
I can tell you, as a kind of a funny war story, I submitted an attorney's fees bill under the Magnuson-Moss Warranty Act in the Middle District of Georgia, and my rate on that case was over $400 an hour. And the federal judge down there said, Mr. Anderson, I've never awarded attorney's fees at more than $400 an hour, and I'm not going to start now. So all I'm going to say is that I've also seen plenty of attorney's fees awards in the Northern District of Georgia for more than $400 an hour, and it was certainly a reasonable fee, but down in Middle Georgia, it was not.
In addition to reasonableness, if you find yourself on the other side of an attorney's fees motion, another defense is that there's got to be a nexus between the conduct complained of and the attorney's fees. So you don't necessarily get your attorney's fees for the entire case if you have isolated instances of bad faith. It's got to be connected, the fees have to be connected to the bad faith. That's all.
Thank you. Thanks very much to Catherine and Don. Excellent session. Thanks so much for all of your participation. And come back next time for Litigation Fundamentals with Henry Quillian.